We're ready.
Well, the girls start with this then. Oh, I meant this end. That.
I'm done. Thank you. I'm an AV specialist.
Variance testing,
Tommy, you ready?
I'm ready.
Okay. Just going over this proposed policy, one of the things, granted, I haven't had time to truly study this thing yet, but I guess one of my initial questions is, who's going to be wearing these things? These body cameras? Is it just patrol deputies? Are we looking at the specialized units as well? If so, which ones? I want to get some clarity on that. if I can.
Who in here, I really don't know who's going to be there.
nature related would probably speak best to that, who's been in mental and development policy.
It will be the patrol deputies, street crimes, K-9, motors, the X-ray units, CST, the SRDs, enforceable deputies, in narcotics. Not every deputy, not every investigator in narcotics, but some in narcotics.
I'm not sure. You said patrol deputies, street, K-9, trying to read my god-awful handwriting. X-ray, what is X-ray?
They're the street crimes unit, crime suppression unit in, they're in District 5, has some extra.
Swing shift units.
Okay.
So essentially it's patrol.
And CST, that's a crime suppression as well, right?
Yes.
Okay, so X-ray and CST are one and the same? Okay. And you said SRD, school resource? Is that correct?
Yes.
Okay. And then you said enforceable deputies. I don't have institutional knowledge to know what that means.
Civil
Okay.
service of enforceable writs.
And then you said some in narcotics. Do you have any working knowledge what the breakdown would be there? I understand that not all narcotics officers are required to wear them, obviously, but when would they not be required to wear them?
I think the thinking was there'll be some assigned to each narcotics unit, maybe, I believe it was 2 per unit, that they would use for execution of search warrants and things like that. The only thing I did leave out, I know SWAT will also be using the cameras also. I think that's a combination of people having other duties where they're assigned cameras, they'll also have them as part of SWAT.
Now, Brady, did you have any issues you wanted to discuss with those, that delineation, and who'll be responsible for wearing them?
Patrol deputies includes supervisors also,
Sergeants.
sergeants?
Any other questions there, Brady? Okay. Now, I know that the policy says that a collar mount is acceptable, because I know some of the deputies have concerns about wearing this device on their head for a variety of reasons. You say a collar mount, how would it be positioned in this area? Is it something that's going to be, that's going to protrude, and it's going to be, get them the range of motion? I've never seen one of these cameras.
Really,
Yeah.
it's part of the kit that comes with the taser. It's, correct me if I'm wrong, Ted, it's magnetic. It's the same camera that magnetically attaches to the glasses. It can be attached right here to the collar.
Okay, so you have,
That came out of, when we did the T&E with the deputies in the field, that was one of their complaints, that it was you know, kind of like with you, Joe, with the glasses flipped up and things like that, that they were running into those problems, so they were looking for a solution, and they suggested a collar mount.
Yeah, that's what came to mind for me was motorcycle helmets. You know, when you're wearing that on and off.
Okay, now, so a collar mount would be acceptable in all cases, or would you require there to be some sort of head mount in regards to one or more units? Would a collar mount be acceptable in all cases? Any deputy, any unit could choose to use a collar mount as opposed to a head mount, correct?
We had, it's preferred.
Where is it? It's preferred, the head mount on the glasses is preferred, but if for some reason they can't use that, then it would be the collar mount.
So would it be the intent from the sheriff's office that you would be required to wear it in a head-mounted location unless you had approval to wear it in another location, or is it going to be
Just personal preference.
personal preference?
I think it's more personal preference. There's not going to be, you have to get written approval or anything of that nature. And it's like you said, if you, kind of like I was using the example there, Joel, on the glasses, that, hey, I'm wearing the sunglasses, so it works better here.
Now, there was a portion, I'm trying to locate it now, where you require your supervisors to review, I think it says on a monthly basis. I'm trying to find it.
So 41, you know, doesn't include mine.
I think it's 41.20.62 on page 7. Immediate supervisors will conduct at least a monthly routine review of subordinates' recordings for quality assurance and training purposes, as well as to make sure the recordings are properly tagged with a case number when one exists. What I foresee, and this is speaking broadly from experience in dealing with the body cameras issue, not with other agencies, is that sometimes a rule like that, a requirement like that, can be used for fairly substantial fishing expeditions against a deputy that has come in disfavor with the sheriff. And I know you shook your head, you don't believe that will happen, but trust me, it can and will happen. And so what I like to see is that we can get almost a limitations period on that. That the sheriff can't go back, and the administration can't go back for time immemorial to review body camera footage to help substantiate a proposed discipline against a
Well,
particular sheriff.
that's evidence, it's a public policy question, that's part of the Florida Sunshine, we're not allowed to destroy evidence.
I didn't say you would destroy evidence, of course.
Well,
I don't want you to commit a felony. Well, maybe I do.
Okay, then I just a
but,
clarification then, what
That
you
you
mean
can't, you cannot, for disciplinary purposes, go back and utilize camera footage that's 3 months old, 6 months old, whatever period of time.
What if a EPN was done on somebody used, not properly using the footage, and they received an EPN from their supervisor, and it exceeds 3 months, and they want to build a case for discipline, you assume we can't use that?
What, I'm sorry, EPN?
Employee performance notice.
Okay, just restate your question, please.
So if somebody's written up for failure to use, or I don't know, whatever reason it would be, are you saying that that EPN is associated with that video would be prohibited from disciplinary action after 3 months?
Yes. So in other words, to prevent the situation that I mentioned a moment ago, where a deputy has fallen out of favor for whatever reason, or the deputy has committed some transgression of a rule, policy, or procedure, that deputy will be viewed in terms of whatever body camera footage exists during the month that the discipline is proposed, would be the only evidence that could be used to substantiate discipline, especially the footage involving the particular call.
Would y'all
And then,
make it-
let me finish.
Okay.
And the administration would be prohibited from going back for 3 months and say, well, this is a pattern, look at this, or 6 months, this is a further pattern.
Would you be willing to put something in writing that
Of
can
course.
be reviewed, language-wise, that can be taken back to our team so that we can actually see what the language is? I know what you mean, And I just don't want to put words in your mouth as far as if we could actually draft a proposal so that that would be something that the major, the chief, and the sheriff. can
I'd be happy
consider.
to. In fact, if you can send this to me in Word, that would be fantastic. I can get that
I
done.
don't know if I can, but I'll try.
We currently don't have a limitation now going back. So, I mean, what, he could go back now. So why are you proposing something that we currently don't have?
Well, actually, now that I think about it, perhaps there should be some form of limitation. Your
Just
seat,
because you think there should be, there's not one now, you know, we're not bargaining.
This is the
what's
first
there
time
now,
that a
we're bargaining,
deputy
you know,
in this agency
the
has ever
impact-
been
you're
required to
asking
wear
what the
a
impact
camera on their
is.
shoulder.
well, actually, the way I see this is mandatory subject to bargaining. And I don't know that your financial rights provision extends to what you're doing here. So we might get into a issue where if we're going to signify our assent to this, there might need to be some considerations given in kind. But we're not there yet. I'm just saying that if we work together, which sometimes we've failed to do in the past, if we work together, I'm sure we can iron out all our differences here and we can move on. And this policy can be put in force in effect. And the body cameras can go on to serve the intended purpose of helping to protect the deputies and helping to protect the citizens. We're here to work with you. But if I'm getting blowback in the first 10 minutes, I can see
Well,
this is
I'm
going to
just
be a long
saying,
day.
where you're asking for something we currently don't have, so I'm wondering why are we doing that? To me, it don't make sense.
Well,
It doesn't make sense.
this
to
makes
get-
sense
It
to me
doesn't
because
make
you'll
sense,
wear a
you're not
uniform.
trying to do something with a body camera. It's something additional to what you don't currently have. It has nothing to do with, to me, with what's the difference with the body camera, but saying I can't go back on discipline, or we can go back now. But now you're gonna limit us on something we have not now that has nothing to do with the body camera.
Well, it does. We've never had a camera on our shoulder before. I think what he's trying to say is that we're not, what we're trying to prevent is that now all of a sudden you're wearing this camera and some supervisor out there is gonna decide, well, I'm gonna be proactive in trying to find things on the deputy. And that's what we're trying to prevent. So, you know,
And I understand that, that's, of course, if you read the literature nationwide, and of course, that's what the biggest issue, the Fifth Amendment. I just have to, as a lawyer, Mr. Blizzard, I think you have to see our point of view is that we have to maintain an accurate personnel file for purposes of negligent retention, you know, civil rights violation. Not that we want to get anybody, but we want to protect us and the deputy, and that is a litigable, how do you say that? Litigious, that's a litigious subject
Close enough.
for people, if you.
Well, okay, I understand your point, and I'm sensitive to your needs. But if an officer is, during a monthly review, a deputy rather, during a monthly review, is depicted on a video as being, as the sergeant is reviewing it, violating a policy, doing something that's inconsistent with policy or procedure, whatever it is, can't even think of an example right now. Well, that should be dealt with then.
Right.
What the county should be permitted to do is essentially maintain that information for 6 months, a year, or time of memorial, and then when the deputy does something to violate a policy, all of a sudden they're going back to their archive of 12 months of video to see, and all of a sudden it's a snowball effect that the deputy is now forced to defend himself on in
Well,
regards to the events that occurred a year prior.
But just to be clear, and, you know, this is all uncharted waters for all of us, there's nothing to preclude a public records request for
You're
that
absolutely
same
right.
thing.
That's different
So-
than your ability to discipline over those matters. I completely understand what you're saying.
Yeah, I understand what you're saying. I think what you're worried about is if there's gonna be discipline arising from a violation of a procedure during that time period, then you should go ahead and either do your report, do your EPN, and do it for that. And if you gotta do 5 of them or 6 of them, that's okay, but you can't, what you don't wanna have happen is if a particular violation occurs, then you go back 4 or 6 months earlier and use that to kind of like, show
the
a cumulative effect.
Well, if you
Yeah,
haven't raised it
ramp it up.
previously, the one I had problem with is the way you phrased it a while ago, so maybe it's different, is if I went ahead and disciplined you, yes, I can go back and use it. But if I haven't disciplined you for 3 months, then I can't.
You
Is
can't,
that
you
what you're
can't
saying?
go back
Because
and
if I've
find
already-
evidence to support your
Correct.
But
allegation.
if I've already
That's what
disciplined
you're
you,
trying to
then
do.
3 month period,
Yeah,
I
if
could
you've
go back
got
and
an
use
EPN
it.
the
But
first
if I
time, the
haven't,
second
I
time
can't
is
go
the-
back. Is that what you're saying?
I believe so, yes.
Okay, well, I understood what I did, if I disciplined you, I still couldn't go back and use it. That's, I took
So
that.
you don't
And that may
want to-
not what you meant.
There's two
That may
main,
not what you meant.
there's two main concerns that the deputies seem to have voiced. One is that we're gonna proactively be able to go back and start weeding through footage when somebody's on the list of undesirables and say, okay, now we're gonna find something on you. That's one concern. But the other concern that deputies seem to have is, years ago, when the sheriff's office implemented GPS on the cars, it was presented to the union that, hey, the only time we're gonna proactively look at GPS is when we have a complaint on you. And we'll use it to, either substantiate the complaint or kill the complaint. And now we all know that that's not the case. We have supervisors that proactively look at it through the use of Force Watch, and sometimes that's the first thing that we go start looking at. So that's some concerns that the deputies have, is how is that going to, that morphed into the ability to watch a guy cruise across the county at whatever speed and get dialed up on the phone. How is that going to equate now to body cameras? Are we going to proactively be looking at body cameras and start hanging discipline on deputies?
I think, in my opinion, and again, I'm a layman, is that because the sergeants will be reviewing this weekly, y'all are smart guys, you spend a lot of time with your crew. If you see a pattern that's emerging, you're going to be looking for it on the as it goes forward, not as it goes back. So I would assume that would be a supervisory failure if this person has demonstrated repeated performance of this, whatever this issue is, and it hasn't been caught. It's not more that the deputy got away with it, it's that we didn't catch it.
All right, and I'm glad you bring something up out of that, is you say be looking at it weekly or whatever. Right now it says monthly.
Monthly.
What are you expecting that the supervisor is going to do? Is he going to look at all the footage that has been captured? I mean, I candidly, I've got 7 people that work for me. I don't have time to go through 7 people's video. I don't know it doesn't delineate in there what level of quality control is expected out of a supervisor.
Brody, right now, how does it work? Normally when someone violates a policy, it comes through the chain of command and then it gets reported. The idea here is that we have to be consistent with our current practice. We can't go outside those parameters anyway. So, you're concerned about this, going back to I call it, buttress a case based on past actions. Typically, the county as a practice has not done that, and I certainly wouldn't be doing it going forward. And there are many reasons why we wouldn't do it, because usually the discipline is shortly after. Sometimes we'll do the investigation. The investigation may take some time. That's the only thing with the 3-month thing is, I don't know how long the investigation would take, but clearly after that time period, if they're gonna do an investigation and report it, that's fair game. The issue is when we look at, for example, I sit on the Internal Affairs Board, we review the cases. We'll go back and look at prior acts, but prior acts only if they've already come to the Internal Affairs, they've been investigated, they've been disciplined. We don't go back in and look at all the stuff outside that. That's what's before the Internal Affairs Board. So that would be consistent with current practice. So it's not like we're...
Well, and I understand your point, and if it's consistent with current practice, that's great, but I'd like to see some level of protection in the policy that says exactly what you just did.
Okay.
That if there's prior discipline, of course it can be taken into consideration. But the county can't go back and start sifting through volumes, hours of these recordings to identify other policy violations that would use, as you said, to buttress whatever discipline they're now proposing. I understand it needs to be maintained for 119. I understand it's available for the free world. I get that. Nothing's going to change that.
If a deputy does something that we want to go back and look at the camera footage, he commits a violation, the supervisor knows it's on video. We're not suggesting that he shouldn't be able to go look at the video and utilize that. What we're saying is, you don't get to take that and go, all right, now let me go back and look at the other 100 cases that he did for the last year and see how many other times he did it. Address the issue at hand and be done with it.
Right, which is why I think would be more in the supervisory realm, because the supervisor's gonna have the most contact with that person, and he's gonna notice, I know you guys notice patterns of poor performance that you're gonna keep an eye on.
Right, and I would.
But that's provided that it gets reported and investigated. And I think Your case is a general one where, yeah, it's a supervisor's responsibility, but it may not necessarily be something that comes up as discipline.
Well, I think
what he's-
they're more concerned about what shows up in their field files. And internal affairs processes has a very regimented process, but EPN, supervisory inquiries, notes in the field file, I think that's what they, am I correct?
Well, yeah. I
Well,
mean-
Brody, I don't think that was the spirit of that.
I don't think it was the spirit either. I think that these are the discussions that we need to have so that we're all on the same sheet of music.
I think it was mainly to make sure that it was being used and being used properly, so and I agree. That wasn't the spirit of that.
No, listen,
For the newness.
I want to be clear on something, and that is that we're not here to try and stop body cameras. We know they're coming. We're here to try and work through this policy and identify where we see some shortcomings in it, get it where it needs to be from a contractual standpoint, so that it protects everybody. And everybody embraces body cameras instead of wants to work against them.
And so, you know, but like Shane was saying, having worked closely with Tim and his group, what that section came from is during the T&E phase, and the numbers are here, there were so many videos coming in, it was a quality control thing.
Right.
It was, there'd be videos but no attached case number, or there'd be a case number that there should be a video, and it was like, okay, where's the video? So that's what that was referring to, more of the supervisors looking to make sure that if, you know, Deputy Smith turned in a video, that there's a corresponding property report and case number to go with it. That's what
And
that
so you're
is.
not saying that they need to sit down and review every recording for every interaction? Okay, so okay, so that helps, okay.
Okay.
So as long as we can get some clear language there, so, you know, I'm a big believer in preventive maintenance. If we can have clear language, you know what your responsibilities are, we know what ours are, there will be
But-
less
but I would say
bumps
that-
and carpet down the road.
As far as the discipline, I think we would have to, we had some talking on that, like you said, Brody, if something comes up today, an allegation against the deputy, that, you know, there may be times where you do have to go back and look at previous, let's just say a deputy transporting a prisoner, and the prisoner makes an allegation that the deputy did something inappropriate. Well, you might have to go back and look at, you know, other prisoners that were transported. I think, as you were saying, was not saving things up that, okay, now I want to hammer a deputy. No, I would think if a supervisor finds some kind of violation, for however he ends up knowing that there's a violation, that he addresses it then. He doesn't save it up and say, okay, well now, as you were saying, the deputy is in trouble for something. Now we're going to go back and include all this stuff. None of that.
I'm not
is
so much
his
concerned about the
responsibility.
first line supervisor doing that. I'm concerned about the administration level, that it could be just, Deputy Blish has committed what we believe is a violation. Let's go back through 12 months of his recordings to see if we can find
Hey, Joe,
additional instances.
I can tell you, I worked with those guys for the last 10 years, and at that senior level, they don't do that, okay? Okay, it's just as I described to you earlier. If it's gonna come to, once it gets to that level, it's already been something that's been investigated, or it's been reported, and it's been evaluated. And I can tell you, with the sheriffs in those meetings, no one goes back and looks at all prior unreported or uninvestigated claims. That just doesn't happen. Now, you may find that in other jurisdictions, but it doesn't happen in this one.
Mr. Hargrove, and I would agree with you that we haven't been doing that. But as everybody in this room knows, that come January, we're gonna have a different sheriff. And whether that person chooses to follow that same practice is a whole nother deal. So
Let me enlighten you.
we need to make sure that we're covered contractually.
Let me enlighten you. He may be a new sheriff, but the problem is that he is essentially an elected manager. He still has to comply with the same rules that this sheriff has complied with, the ones before him, and the ones in the future that will comply with. So that's not going to change because you get a new elected sheriff running the operation.
I don't know. I mean, I hate to be chicken little here, but, just because we don't want it to happen doesn't mean it won't.
Well, that's because you don't know the rules or the regulations that we follow, but those are in place. We can't change those.
Okay. What rule regulation are you referring to?
I'm talking about the merit rules, I'm talking about the SOGs that we have out there, I'm talking about what we have to comply with, and
If
Frank-
there's a
Frank-
specific merit rule that I need to be looking at,
well, you can look at the chapter, you can read it, it's chapter 86.
okay. Is there a more specific section I should be looking at?
No, I think the chapter would be good for you, because that way you'd be familiar with all the components and sections. and how they apply. The main thing is that we have standing SOGs, and those are established in compliance with not only county regulations, but the charter. What I'm trying to say to you is that those things can't be unilaterally changed because you have, even Ben Johnson can't change them. So just because you have an elected official, he's not truly an elected official, he's really just what we call an elected department head, who really, he doesn't control the purse strings, that's all controlled by the county. So it's different than if you were in Orange County dealing with the sheriff there, where they truly are elected officials, they have to run departments. They're constitutional officers. This sheriff is not a constitutional officer. That's a whole different ballgame. It's just like, he would come under the same rules that the CFO would, the county manager, Tom Moats, any other department head. So it's a subtle, it's a distinction that a lot of times people understand, that with the Charter County and the way we're set up, that these guys are really truly not constitutional officers. So, you know, someone coming in to do that, or let's say you have a new sheriff that comes in and they want to bring in their new staff, that ain't going to happen here, because they can't do that. That's by charter.
The employees are actually controlled by Mr. Denny in the charter.
I understand what you're saying, and I will look at chapter 86, but.
But I understand your.
A moment ago, Laura invited me to propose some language, and that's what I'll do.
Well, and I have, you know, you and I, we all have history, and I just know that little words can make a difference to what the meaning is. I just want to make sure our meaning and your meaning is the same meaning.
Okay, makes perfect sense.
I do want to clarify something, and that is, I'm fully aware of chapter 86. I've read it front and backwards and sideways, and there's nothing in chapter 86 that prevents somebody from changing the sheriff's office policies, okay? These are written by the sheriff and signed by the sheriff. So I agree with, there are certain protections provided by chapter 86, due process rights, but it does not stop a new sheriff from coming in here and going, well, there's nothing in their contract, there's nothing in the merit rules, I'll put it in the sheriff's office policy, and when you violate it, it's now a violation of sheriff's office policy. And then the county, you're gonna slap me with an IA, and you're gonna put that little catch-all in there that you do on every single one that says anything that reflects negatively on the county, and now I'm fighting as to whether or not I keep my job. So I appreciate your position, but I think probably the safest place for the members at this point is probably to make sure that, as it relates to the use of body cameras, that we work through all these things, and the things that we feel are important as we resolve them, that we have it in some kind of written document.
Okay, I understand it, but now how do you protect this one? The spirit is not for you to go through every film, so nobody goes through it. 8 months later, a citizen comes forward and says, this happened to me on this date. And your proposal, we can't go back and use it, but we never even saw it.
And that's the point,
We
that's the
never
point I was
looked at it.
making
I
about this
understand that,
prisoner
and I would build that
transport.
into
Somebody
this.
comes up with an
Okay,
allegation,
that's one of our concerns.
and somebody else is
Because
gonna
we're not
have to be
asking
able to
these-
go back and look at that.
Because we're not asking these folks to go through all the film every month.
Well,
As they said, they want to go
part
through,
of the
make sure
trouble
it's
with this
there, and make
language
sure it's.
is that if you read
cataloged.
it certainly doesn't say that's not the intent. It may be the spirit, but we both know that language is what matters in this room, outside of this room, and in a courtroom. And just for your own protection, if you have language in here that says the supervisor shall review the tapes, and the supervisors aren't doing that, does that only deepen your hole in terms of potential negligent retention and civil rights violations? I think it does. So it makes sense to me, although God knows I'm not your counsel, that we have some level of clarity here about what the supervisor's obligations are, so you're not sitting in a courtroom 2 years hence having to defend this language and having to answer to why your supervisors weren't reviewing every tape, why you were reviewing every third tape, or something more consistent with the very language of this policy. Right now, the spirit that you're indicating is not reflected in this language. And also, as to chapter 86, I mean, it's been a while since I've read it, since the last personnel board hearing, but I don't recall there being any language in there that prevents the county from reaching back in time and reviewing past instances to buttress, as you said a minute ago, a current proposed piece of discipline. I don't remember it being there.
No,
Now,
it's
if I'm wrong, correct
You're
me.
not, that's what I was saying earlier, it's not there.
Okay, then the point about chapter 86, I think, is an illusory one, and I think we need to have some language in here to
To be
protect.
clear,
our-
if there is a citizen's complaint against a deputy, that the person signs, they swear to it, they notarize it, and they bring forward a legitimate citizen's complaint, there's nothing on our side of the table that's gonna say, you can't look at that video,
Right.
okay? that is not the intent. The intent is to stop us from going back proactively, trying to find things against the deputy. Okay? So just so we're all clear on that is,
Okay, I
if
understand.
somebody makes a complaint, then by all means, if there's video on it, then we should look at it. But it can't just be, well, we think there's a complaint, or, listen, and that, you know, it brings up other issues for us that we can talk about with regards to following policies and requiring people to, you know, if they're gonna make a complaint on a deputy, we need to make them sign the complaint, you know? You wanna take a deputy to task and hold them accountable, then be willing to put your name on it and sign it and take them to task on it. Because these guys, their career's on the line for some of this stuff.
In this language on 41.20.62, immediate supervisor will conduct at least a monthly routine review of subordinates' reportings for quality assurance and training purposes. I mean, that could be easily tortured to mean that, well, Sergeant Hughes didn't do a sufficient job of reviewing the videos of the deputies under his direction. And now we have this new issue that's arisen in regard to a potential civil claim. Does that mean that sergeant's going to be held to task? I mean, this language says that he's supposed to review the tapes. It doesn't say that he's supposed to make sure that the right case numbers are on the right video. It doesn't put any limitations on what type of review you're supposed to conduct. So again, this puts you in a bad position potentially down the line with litigation, and it certainly puts the sergeants and also the deputies, as I explained a moment ago, behind the 8 ball as well. Because you don't explain what the sergeant's duties are. He's already indicated to the sergeants that there's no way they can review these videotapes.
No, and
It's impractical.
there should be detail with that. I don't dispute that.
So if we can get some clarity there, that'd be great. And if you don't have this in Word, I'll just retype the provisions that we've highlighted to this point. The ones that we'll highlight and later in this meeting, just send it off to you. But bottom line, you know, we know the cameras are really something that's inevitable. We just want to make sure we have a soft landing and that you understand where we're at and we understand it as well. Mutual understanding, so we don't have future issues, more bumps in the carpet. We've had enough.
How does a supervisor record quality control?
Bob just brought up a valid point. Once we get an understanding of what the supervisor's responsibilities are in regards to review of the video, how does he record that, he or she record that understanding, or that review? Is there some record keeping that's already in place or being proposed that we could look at? Because if you're putting a responsibility on the supervisor to do X, Y, and Z, he or she is going to want to be able to document it so that he can't be called into question later about his or her review.
If, like I said, maybe the verbiage in here, like I said, could be changed a little bit, but why that's under quality control is, like I said, it was about the quality of videos matching the case number, videos being turned in, or I'm sorry, case numbers being there, or the other way around, videos being there and no case number attached to it. That's why it's under quality control. It's not under discipline or supervise, you know, it's, so the record would be if Deputy Smith keeps turning in reports or videos and there's no case number to go with it, that's going to be the documentation, because here it is, and his supervisor.
So there's no obligation on the
It's like
sergeant.
turning in a report without signing.
When we went to doing digital photos into evidence, we at one time got this list where it had hundreds of cases where the deputies put in the wrong code on the property sheet or whatever, and we had to go back and get them to do supplement. It was a mess, but we got it done. I guess what the sergeants didn't catch this as they reviewed reports, because they look at, oh, they put his evidence in and whatnot. So I guess where I go with this is, would it be more beneficial to say quality control for ensuring that stuff should fall with records or whoever's doing the video evidence, and that the supervisor will ensure that any anomalies are corrected by their subordinate?
That's really not practical, right, because there's so many reports and videos going to be turned in. And that's what we were doing in the T&E phase, the people from Tim's shop in IT were the ones basically doing the quality control, saying, here's a case number, or here's a video, but there's no case number attached to it. So then it would have to be kicked back. So it really has to be the supervisor in the field to make sure, like I said, I kind of equated to the deputy signing the report, making sure the report's right.
So are we only reviewing, are we only reviewing the video, or the deputy has a case, he does a report, and we're reading the report, oh yeah, he had body camera video, I go over to the property page, yep, he's properly logged it in here. Is there another step to that where then I now have to go to evidence.com and verify it's done correctly there? Am I doing it just on cases where he's written a report, or am I doing it on every single video upload? I mean, that's the question is, how much more time is the sergeant gonna have to invest to managing quality control over videos?
As far as every video, no, it's not every video, because every video is not going to have a case number attached to it. It'll just be the cases where there's a report done. And I'd ask Tim, how does the supervisor?
Well, supervisor, obviously checking the property report is one thing, but the other thing, we're developing a process to automatically tag the video once we see a case number assigned in CAD, so we're trying to alleviate some of that work as well. I think you're gonna have some anomalies where we're not gonna be able to automatically tag it with a case number. And when I say tag it with a case number, why that's important is because that's the trigger mechanism that gets it put into our digital evidence system, similar to where the photos are going. It's not a manual process, we're gonna automate that. But where we really expect that maybe the supervisor to go check to make sure a case number was assigned is, say a deputy went on a case 2 days ago, and then today they went on a follow-up call, so they didn't pull a new case number in CAD, they're doing a supplement report. So to me, a supplement report for a case that was pulled a couple days ago, that's where we expect to maybe do some spot checking to verify, did they properly tag that video? Because the key to all this is if they don't tag it properly, we lose evidence. And like I said, we're trying to automate the process for original reports, but the supplements are where we get a little assistance.
Are all the videos getting retained or no?
No. Well, there is a retention policy, but it's different retention policies.
Because if every time you turn it on, if it automated to the event number,
If,
you always have it, you can never, you can.
no, the way it works, if a video's turned in, connected to a case number, it defaults to whatever the retention guidelines are. If it's, a certain type of felony, you have to keep it for this many years. If it says you have to keep it, if it's not connected to a case number or a citizen's complaint or something like that, then it stays for 365 days, and then it goes away.
Our key is making sure that if it's evidence and it's related to a case number, we don't want to just have it roll off automatically after 365 days a year. So like I said, we're going to automate the process for those original reports to automatically tag it and get it put into the evidence system. What requires the deputy's intervention, though, is that supplement report. He's doing a follow-up for a case that happened a couple days ago.
What about having Central reopen the original call, put you back out at that location so that it is attached to that case number?
It's really,
You don't have to worry about losing it.
our only way to automate it is based off when the case number was called. So even if they put you back on the call, I don't know, we'd have to explore that, but I mean, really it's triggered off when the case number was pulled. And we've explored different options, trying to alleviate all the manual effort that has to go into that. But I think where we're at, we can't solve technically are the supplements. It's like I said, a follow-up that happened for a case a few days ago.
Same process for the tickets, but they have to tag the tickets in there to do those as well. Like citations.
Citations. No.
Because citations, they were tagging videos also.
Yeah, I mean, it's the same thing. If you pull a case number for the criminal citation, yeah, the video needs to be tagged. But again, we're going to try to automate that process. But obviously, if we have a call and you say you're doing radar and you pull 20 case numbers, there's another example where we can't automate that, because we don't know which video goes with which case number. But those are the exceptions to the rule. Like I said, we're trying to narrow it down so that when you're asking about how many, I think we can define some certain criteria to say the sergeants need to do some spot checking on these type of calls.
How is the plan when you have a deputy who, say he does a traffic stop? It doesn't rise to the level of a criminal violation, but the person is rude and the deputy's running it on camera. The way we currently do things is we don't pull a case number for that. We write them a ticket and we're done. Now there's camera footage that we want attached to that. How would you attach that to that camera footage without a case number?
The deputy himself, the deputy himself can actually download the video. They have access to their own videos and they can download the video.
But if it's not got a case number attached where it's gonna be stored, he gets a subpoena for something 6 months down the road, how does he go back and get that video if it's already been purged?
Well, it's all
It would be
part of it,
365 days.
365 days.
It's kept for a year, yeah.
Every video is kept for a year.
Every video, regardless of its evidentiary value, is a year.
But if it's evidentiary, then it would be
It
kept
kicks
longer.
into longer. Okay.
You would be looking to use that for like traffic court.
Sure.
So it would be for a year, it would be kept, which would be consistent with practice of Eagles, majority of them.
Obviously, if they found it that negative, they could pull a case number and memorialize it that way too.
Well, I guess where I'm going with it is I don't want to see our deputies get into this mode where all of a sudden we're doubling their work because we want to have a report with every video that they want to have saved or something like that. But if it's available for them up to a year to go back and, oh, hey, I remember on this date I stopped this guy, I remember it being on video, then they would have that at their access.
It actually mentions in here on traffic citations to make those notes on the citation. If you had a video, that would be beneficial for that.
So are you putting that on your copy, the violet, or are you putting that on the white copy?
On the officer's copy.
Okay,
So that would give you a reminder if you wanted to use that.
okay. I did see something in there about that, just trying to connect the dots with it. So, just a thought, though, as kind of rounding out this quality control thing is, it sounds like you guys, from the IT side of things, found it to be quite a bit of work. And now, and I realize there's only a limited number of you compared to the number of us that are out here doing patrol, from a supervisor standpoint, but at some point, I think it would be beneficial to say, well, let's get a couple supervisors to try that real quick and see how much time they are having to invest in it, because I just don't want to find us getting to the point where our supervisors can't get out of the office because they're having to review this, a couple of reports, doing chronos, doing whatever else is thrown their way. Pretty soon, we're going to have sergeants that they're so entwined with the computer at the office that they're not going to be supervisors anymore.
I think during the T&E phase, yes, it was a bit overwhelming, but remember though, we did not have the automated process in place either. So we were having to, and again, our goal during the T&E phase was to get a valid gauge on how much video we're gonna have based on the current activation policy, how much is the evidentiary value and this and that. So we were at that time reviewing every video because we needed accurate numbers coming out of the T&E phase for cost estimates and determine how much video and how much storage we were gonna need. So I can tell you, yeah, during the T&E, it was a little overwhelming, but that was a special circumstance. Like I said, we will have the automated process in place, and we're not expecting, I don't think anybody's expecting a 100% review of all video. We can specifically define, these are the type of cases you need to be looking for. A lot of the quality control came out of just simply not having a property report, and that doesn't require reviewing a video. I mean, a supervisor looking at a report, I mean, we were doing the same thing. We would look at the report and say, we know he had a camera on. If this is the type of case, you probably should have had a recording. So we'd go check and see there was a recording, and then we'd send it. But I mean, the supervisor could simply say, you know, you need to do a property report. And I think that was the biggest time-consuming thing for us. But again, it was only because we had to do every single case because we needed accurate numbers.
One of the questions I had as I went through through this is, I didn't really get a clear sense of when the deputy is supposed to activate the recording. Can you help me understand where that line is? I understand if you see a criminal violation, of course. But what other circumstances would require a deputy to activate the recording? I understand that you accept just casual interactions with the public. Well, where's the line? Because we don't want to find ourselves in a situation where we're accused of not recording, obviously. Or we don't be accused of a situation of recording when we should not have.
That was my concern when I started this process. Very much. Do you want to go ahead?
And we did, if you go 4120.32, it starts in that section, required activations, when and where to record. We went into some detail, as you said, you can't cover every circumstance out there, but there is a list there. And a lot of that came from, it's evolved when we did the T&E from the deputies in the field. I can tell you one of the things that came up was Baker Act. We didn't think about Baker Act, and it was one of the things that came up in the T&E where one of the deputies said, it was like, yeah, you're absolutely right, that's probably something we should put in there. So I'm not sure of what's not really explained in that section, and then, it goes into the enforcement action, it goes into criminal investigation contacts, and then the next section is when not to record.
Well, we all know, at least I believe, that even a casual interaction with a citizen can quickly devolve into anything but casual. Where's the line drawn there? I mean, is it?
I think it has field contacts, covers field contacts in there.
It does mention that casual contacts did not need to be recorded, but if they rose to a level where you needed to record those, then they would activate at the opportune time to do that.
So in 41.20.56B, did 41.20.56, page 7, talks about deputy exercise discretion not to record. Is that something that would be respected if the deputy had whatever reasons they felt were legitimate not to record interaction, as long as it wasn't mandated to be recorded under the prior page? That's something that the administration is comfortable with, the deputy using his or her discretion to decide whether or not to record interaction?
Well, I think if you read that, if you go further down too, the deputy would have to document why he did not, and why he exercised that. Could it be that, I can't think of the situation right now, but maybe, because we've tried to cover everything. I was gonna say private conversation between two deputies, we've covered that. That's not being recorded.
agent by accident.
And we've covered that, that's in there, undercover agents, CIs, not to be recorded. That was in there in case there's something we haven't thought of, that the deputy may have a legitimate reason, and if he's able to, he'll be able to document that, why he turned it off.
Go ahead, Bob.
Under 41.20.45, am I reading this wrong, or is this some type of glitch?
What's the last two numbers, Bob?
455. The VWC shall not be used to intentionally or willfully record, it says A, victim and witness interviews outside the presence of the suspect.
Yeah.
So if I'm interviewing a witness, the suspect has to be standing here?
No, it's saying that you don't have to, if you're in the house privately with, say, the victim of a sexual battery, of a domestic violence, if you're just with the victim, you don't have to record that, you don't have to activate your body camera. But if the suspect,
Shall not.
Doesn't say that.
Yeah.
yes it does, the body worn camera shall not be used to intentionally record a victim and witness interview outside the presence of a suspect.
Yeah.
Obviously, one of the common things that we get out of the state attorney's office is Where's your witness statement from your victim?
Yeah.
Well, what better statement would there be than to have that video footage with the victim?
Yeah, that's
Or a
typo.
witness?
And if you go down to B,
You're right.
it says interactions with parents of child abuse investigations. Well, the last time I attended a child abuse seminar, 75% of your suspects are the parents. So you would be disengaging your camera going to a child abuse case in this situation?
And inside jail facilities, I can imagine that, that would be a situation ripe for people making admissions or other statements against their interests that we might want to record.
Yeah, I
You
think
think,
we
Rudy?
run into
Does
the
that make
problem
sense?
there,
I don't
bringing
think
the
the jail
equipment
allows
into the
the
jail.
recording.
I mean, none of this prevents the deputy from using a recording to, like you said, record an interview, you know, a recording.
What's the problem with the jail?
They won't even let digital voice record.
Yeah.
As Mr. Moats so kindly pointed out, those are Mr. Deneen's employees. So maybe he could have Mr. Deneen tell the jail, well, we're going to allow this because it's beneficial to law enforcement to be able to record that suspect through the booking process.
I've never heard of not recording things in a jail.
And the
They will
intent,
have phones in there, they
Not to
will.
mention, you bring evidence if they found contraband that somebody wanted to search.
that A, that's obviously a typo. What the intention was, Bob, is what I said is, we were limiting the amount of times that the deputy had to record, you know, a victim or suspect that maybe, or witness, sorry, I'm gonna confuse it even more. A victim or witness might not be comfortable talking to the deputy if they know, hey, I'm being videoed. So if it was outside the presence, again, the example I started to use was like a domestic violence call. Deputy goes, the victim's inside saying what the spouse did to her, that doesn't necessarily have to be recorded. If it's a situation where you show up on scene, the suspect is still there with the victim, then yeah, you would be recording, you know, that interaction. And the intent of B was the interaction with parents of a child abuse investigation was if you went to contact the parent of a victim of a child sex abuse investigation, then it wouldn't be the video of the mother telling you or the parent telling you what happened to the child.